Y'all. Hey, happy Wednesday. Hope you're all doing well. It's time for True Crime Wednesday. Just want for those of you who might be new to the channel, because I forget sometimes that we've had so many wonderful new subscribers, let me introduce myself. My name is Lori Hellis, and I am a retired criminal attorney, did both prosecution and defense. And I am writing a book about the Lori Vallow case. And I'm here to answer all of your true crime questions. Starting out with on True Crime Wednesdays, we do a little roundup of lots of different cases. And now that the Vallow case is sort of in a real lull because we're waiting for Lori's sentencing and Chad's trial date. In the meantime, there are a lot of other true crime cases that we need to talk about. So welcome. If you are new to the channel, please take a minute, pop out and hit the subscribe button as well as the notification bell. Please hit the likes because it does help us with our algorithm. But please pop out and subscribe. We do go live on little surprise lives if something interesting happens. And if you don't subscribe and don't hit the bell, you won't know about them. The other thing is that our chat has gotten so busy that we've had to turn on the subscriber only function. So if you are not a subscriber and you have been trying to post in the chats, you need to be a subscriber in order to post in the chats. We love our chat, and I go through and read them all the day after. I go through and read all your comments that you put below as well, and I answer as many of them as I can. We love our comments and we love having a chat going, but in order to keep up with it, because we usually have so many people in chat, we've had to slow it down and we've had to turn on the subscribers only mode. So that's another reason you should subscribe if you want to join us in the chat. So we have a ton of things to think about and to talk about. So let's dive in. Those of you who are not new to the channel, who have been with me from the beginning, know that I moved to Idaho in order to cover the Vallow Daybell case and write a book. So I'm deep into writing a book right now, which is why you're not seeing quite as many newsletters out as I have been in the past. Because to tell you honestly, when I'm done with a day of writing, the last thing I feel like doing is writing some more. But I will try and get some newsletters out. I know that y'all enjoy some of the more in-depth discussions about legal issues. So we'll be tackling some legal issues as they come up. But for now, one of the cases that's been of interest to me has been the Kohberger case. And that is the University of Idaho case that happened last year where 4 University of Idaho students were murdered in their off-campus home. So Brian Kohberger was arrested in December of late last year. He was being held on a DA's information, which is the initial charging document, and he was waiting for a preliminary hearing. Now, in Idaho, interestingly, constitutionally, there are 2 ways that you can charge someone with a felony. Either you can take the matter to a grand jury and have a grand jury decide that there is sufficient evidence to issue an indictment, or you can have a preliminary hearing and have a judge determine that there is probable cause, that there's sufficient evidence to hold the person over for trial. So either way, and it varies from state to state as to which form the state commonly uses. Idaho likes preliminary hearing, and typically what happens is there is a preliminary hearing for just about every felony charge. However, they do have the option of using a grand jury. Now, those of you who've been with me a while know that we saw that happen in the Lori Vallow case. Initially, we saw a preliminary hearing in Chad Daybell's case having to do with the very first charges. Right after the children's bodies were found in his backyard, they had a preliminary hearing. They charged him with tampering and destroying evidence, several counts of that. And it was kind of a placeholder. I have a bit of a scratchy throat tonight, so forgive me if my voice gives out. Anyway, the charges were a bit of a placeholder while they were continuing to investigate, and as a way to keep Chad in jail. Chad and Lori both, actually. And so they had a preliminary hearing on those charges. And those of you who have been with the case a long time remember there was a 2-day preliminary hearing. That's very typical for Idaho. But Lori then waived her preliminary hearing after Chad's was done. And then when it came time to indict them on the murder charges, in fact, they put that to a grand jury. One of the reasons why a grand jury is used is because in a high profile case, you don't want all that information about the case getting out. And so grand jury proceedings are private. They're never open to the public, and the transcripts are sealed. They're confidential, can't be, they're never available to the public. So we were waiting for Brian Kohberger to have a preliminary hearing. He waived his right to a speedy preliminary hearing. The requirement was that it be had within 14 days. He waived that right, and it was set in next month. And then kind of out of the blue, the prosecution announced that they had submitted the case to a grand jury, and the grand jury had returned an indictment. So no preliminary hearing in June as we had originally expected. He was arraigned, and trial was set for October 2nd through November 12th. Now, is that going to happen? Really doubtful. But at the time of Kohberger's arraignment, that's when the clock started to run on the time that the prosecution has to issue a notice of intent to seek the death penalty. So right now, we're waiting to hear whether or not the prosecution is going to issue that death penalty notice. In the meantime, those of you who've been following the Vallow case know how frustrated everyone was with the fact that the court did not allow cameras in the courtroom. And so there was the only access was the audio recordings that were released after court was out. There was no live stream. And at least at this point, there have been no live streams of Kohberger's hearings either. The hearing has happened, it has been videoed and then released later after the hearing is over. But there have been a lot of, there also was the Kohberger case, they also issued, the magistrate court issued a gag order. So several news organizations, a consortium of news organizations got together and filed suit to try and get the court to lift the gag order because it's a blanket gag order. And it's gone to the Idaho Supreme Court. The Idaho Supreme Court's bucked it back. And so now it's back in the trial courts, back before the trial court. In the meantime, prior to his indictment and his arraignment on the indictment, his case was being heard by a magistrate. That is a lower court judge. It is in Idaho. And once he was charged with the felonies, then the case was elevated to the district court. So now it's a completely new judge. This judge's name is Judge John Judge, apparently. And so this judge has the ability at this point to take a second look at that at that gag order and everything else that's involved in the media. So there was a separate case that was filed by the media, and now this judge has wrapped it up into Kohberger's case. There is a hearing set on June 9th, and in that hearing on June 9th, oh, hang on here, I wanted to make sure I had the right date, June 9th, the judge has invited all of the people who are involved in the issue of the media to submit briefs about their arguments having to do with whether or not the gag order should stay in place. The judge also invited them to put out some initial briefs on cameras in the courtroom, which I thought was really interesting because there isn't really a motion in front of the court right now having to do with the cameras in the courtroom. However, the judge wants to address the issue. So on June 9th, we're going to get some hearings on the gag order and on at least initial arguments on cameras in the courtroom. So some of the things that that I did want to talk about, one of the things I wanted to talk about with Kohberger is we recently heard that he was connected to, no, I take this back. I don't want to misstate this because this has been a problem, that we've had some misinformation. And what happens sometimes is two things get conflated into one. And I don't want to contribute to that. So let me be clear. Law enforcement, both in Idaho, Washington, because he was living across the Idaho-Washington border in Washington, where Washington State University is, and in Pullman, Washington. And so Washington, Idaho, and Pennsylvania, which is where he was from and had grown up and gone to college, have all been looking at some of their unsolved cases and asking whether or not it's possible that Kohberger could have been involved in those as well. This is very typical. Anytime that you have a case like this where you have what appears to be somebody who has no prior record, you're going to go back and look and say, I wonder if they could be connected to some of these other unsolved cases. And oftentimes they do discover. I mean, Ted Bundy was linked to cold cases that no one knew about. The Green River Killer was linked to cold cases. So it's not at all unusual in these kind of cases for law enforcement to do that. So one of the cases that has been a bit in the news is a woman who disappeared and no one knew where she was. And a year later, her body was found about 30 miles from where Brian Kohberger lived. Now, unfortunately, we live in a society where murders happen and bodies do turn up after significant periods of time. But law enforcement looked to find out whether or not Mr. Kohberger had any connection. And Pennsylvania law enforcement announced that Mr. Kohberger had an alibi for the particular night or time that this woman disappeared. So he was not a suspect. What happened at the same time, and probably very likely unrelated, was that Mr. Kohberger's parents were called before a grand jury in Pennsylvania. Now, the grand jury in Pennsylvania, law enforcement said, this has nothing to do with the woman that was missing. This has nothing to do with anything, but oftentimes what happens is people are called in front of a grand jury because they want their sworn testimony. No matter what they're going to say, they want that testimony nailed down. They want sworn testimony nailed down. So then what happened, sort of in quick succession, was a motion that was filed by the prosecution asking the defense about an alibi. So suddenly, people have conflated these two alibi issues that are completely unrelated. So I want to get into that. So in Idaho, there is a rule of criminal procedure that says that anytime after arraignment and or within 10 days, if the prosecution demands it, the defense must give notice of their intent to seek an alibi defense. Now, those of you who've been with me through Vallow, we did this in the Vallow case. The prosecution sent the state a demand for an alibi. It turned out the state or the defense didn't produce that notice until much later. And then they filed their notice of intent to claim alibi. So in this case, the prosecution, following the rules of criminal procedure, it's very typical, sent the defense a demand that they give them any information that they have about their intention to claim an alibi. This has nothing to do with Pennsylvania. It has nothing to do with his parents, other than the fact that the parents have been called before the grand jury in Pennsylvania. It is an investigative grand jury in Pennsylvania. And they probably are doing their best to nail down any information that they may have from Kohberger's parents. Now, we don't know how much Kohberger's parents knew. We heard on social media that one of his sisters was rather suspicious since he had just come from the area where the murder had happened and was driving an identical car to the one they were looking for. So we don't know how much Kohberger's parents knew or whether or not they were protecting him or covering up what they thought might be a crime. So I'm sure the authorities are investigating those sorts of things. I don't think it has any real concrete meaning at this point when it comes to Kohberger, and it does not mean that he's claiming that he has an alibi. It means that the prosecution has put the defense on notice that if they're going to claim alibi, they need to give that notice. So nobody panic. But the things I do want to talk about are whether or not we're going to see another change of venue. And I think it's very possible because the area where Moscow is every bit as small and as ill-equipped to deal with this sort of case as Rexburg was. In addition, it's a college town. So not only have they heard about this because because of its notoriety, but of course they've heard about it because many of the people who live in Moscow work for the university. And so you really have sort of a built-in bias there. So I absolutely expect that there's going to be a change of venue. And I think you likely will see it come to Boise because that is once again, the largest population and the most diverse population, where we might find people who while they may know about the case, don't know a lot. So, so I think we're going to see that. I would not count on trial happening in October. Now, Kohberger has not waived his right to a speedy trial. I think he will. And I certainly think he will if the death penalty is sought. I cannot imagine the death penalty not being sought in this case. I think that, whether a prosecutor files for the death penalty or not is first of all, the case has to meet the statutory ground. So it has to fall within the category of crimes that are eligible for the death penalty. This one does. And usually it's in furtherance of a felony or associated with a felony. So he's been charged with burglarizing their house. That's a felony. In the commission of the crime of that felony, he also committed murder. So it qualifies for the death penalty. So, but the other considerations are political. Remember, district attorneys are elected. And so if a DA wants to get reelected, they need to respond to their constituency. And I cannot imagine an elected DA being able to defend not seeking the death penalty in this case. So I expect that we're going to see a death penalty notice shortly. And I believe that will most certainly trigger a couple of things. It'll trigger a waiver of his speedy trial rights, and it will also trigger a motion for change of venue. So that's my prediction. We'll see whether I'm right or not. So moving on to Vallow Daybell. Y'all know Lori Vallow was found guilty on all the charges. She was found guilty on all of the murder, conspiracy to commit murder, theft charges. She filed a motion for a new trial. That is still pending, but I don't put a lot of stock in her getting a new trial. One of the things that they said was the basis for asking for a new trial was that they had that a juror had been interviewed and seemed to know more than he was presented at trial. As I suspected, he said, yeah, because I went home and watched Dateline after the trial was over and saw the body camera footage and some other things having to do with the Arizona case. So I don't think that Lori gets a new trial out of that. I think there are issues that they're going to raise they will raise on appeal. Remember, we talked about this before. Appeals take a long, long time. So Lori's case will be, they will file a notice of appeal. And the next thing that will happen is that they will ask for a certified transcript of the trial. Now, the transcript has to be created by a transcriptionist who is certified by the court. And that can take a very long time. It can take up to a year, really, especially with a 5.5-week trial. That's a huge job. It's going to take a very long time to get it done. And so then once the transcriptionist files their notice that the transcript is complete, then the court will start telling the parties, you need to have opening briefs done. So your opening brief is the argument that you make to the appellate court about the issues that you want the appeals court to hear. So that's the point that the defense is then going to go through the trial transcript and through all of their notes and the discovery, and they're going to pinpoint the issues that they believe could be error and potentially reversible error. So they're going to make those arguments to the appeals court, and then the appeals court will set a date for oral argument. There will be an opening brief, there'll be an answering brief, sometimes there are rebuttal briefs. So that takes months to get all of those documents done. And the appellate court has a very full calendar, and it sometimes takes up to a year to get your oral arguments scheduled. So I am not anticipating that Lori Vallow is going to get a quick appeal, or that somehow she's going to get a new trial thanks to the appeals court anytime soon. I think the soonest that we're looking at a decision from the appeals court will be 2 years. Could be longer. So now, Chad Daybell, we still do not have a trial date for him. Now, if you remember, just before during Lori's trial, just before it was over on the 4th of May, they held a status conference, a scheduling conference. And during that conference, the judge asked for trial dates. The DA said, well, we could be ready right after the first of the year. We really don't want it to go be before the holidays, but we could do it after the first of the year. And they kind of went back and forth. And then John Pryor said, I want it in June of 2024. So I'm not sure the judge is going to set Chad's trial out clear for another year. I suspect we may see something in the fall. But a lot of that is going to depend on whether Chad actually wants a trial or whether there are plea negotiations going on. And it depends an awful lot on Ada County and their docket. So it seems to me that there's stuff going on in the background that we're not privy to. I think that there's some serious plea negotiations going on. And the reason I think that is because, A, the prosecution does not want to retry this case. It was a lot, and it cost them a lot. It cost the county a lot, and they don't want to retry it if they don't have to. And B, there are some reasonable arguments to be made about there being due process and equal protection issues if Lori doesn't get the death penalty, but Chad does. So it seems to me that there's probably some earnest plea negotiation going on. Now, it may be that they're not going to make a final decision on plea negotiation until after Lori is sentenced. That would make some sense, just to make sure that they understand all of the ramifications, all of the nuances of Lori's sentence, so they can duplicate that for Chad. Because we won't actually know Lori's sentence until the judge sentences her. And then the DA will be able to go forward and say, well, now that we know what Lori's sentence is, we'll duplicate that for you. So I sort of think there's a little bit of lull going on. Now, if I were John Pryor, I would still be steaming straight ahead with preparing for trial, getting all that DNA stuff done, getting everything done that needs to be done. All of the retesting, all of those things that he wanted done. So I'm sure that that is what's going on with John Pryor, but I'm also sure that there's a lot of plea negotiation going on. So I don't know that we're going to hear anything about a trial date for Chad until after Lori's sentencing. And Lori's sentencing is July 31st in Fremont County. And yes, I'm going to try and go. We'll see whether the judge lets me in or not. Let's move on to Delphi. There's a few cases that we have talked about before, but since the Vallow Daybell trial has been going on, we've been totally absorbed in that, and we have not had a lot of conversations about some of the other cases. So let's move on and talk about Delphi. Now, for those of you that aren't familiar with the case, this is a case where two young girls, 13, Abby and Libby, went for a walk on a trail in Delphi, Ohio. Oh, you guys, my brain is just that fact fell out. So And Reese, and it went unsolved for 7 years. These two young girls were found brutally murdered in this park. Went unsolved for 7 years, and then suddenly, it to everyone on the outside, it felt like out of the blue almost. Law enforcement arrested Richard Allen. Now, law enforcement has said before that they are not ruling out the fact that there are other people involved. And in fact, there was another person of interest who has since died, who may very well have been involved. So Richard Allen was arrested and he was put in jail. And he was, because of the notoriety of the case, he was put into segregation. He basically was in solitary. And the conditions were not great, according to his lawyer. And it doesn't surprise me at all. We know county jails are not great places to be. And his health was suffering. His health has gone very steadily downhill since he was arrested. He's probably lost he's lost a huge amount of weight. If you see the arrest pictures versus his now pictures, and he looks like he's in very poor shape. So this is a case we do not know very much about because there's a gag order in place again. But we do have a couple of things that we do know. And one of our followers asked me if I would talk about this. So I'm going to look at the note here that's on my other screen so that I can, so we can explain it. The court, having had the defendant's motion to quash subpoena under advisement, now grants the motion to quash the subpoena ducis tecum, that means with documents, directed to Westville Correctional Facility relating to the defendant's mental health records, mental health evaluations, and/or exams. Apparently, either the prosecution or law enforcement wanted those records. And we all know those kind of records are usually not discoverable, particularly examinations. Now, the only way that they could get mental health examinations would be if the defense intends to offer them at trial. Then you can get the reports. But if they're not going to be offered at trial, you can't get them. So the judge granted that motion to quash. The motion to quash the subpoena ducis tecum directed to Westville Correctional Facility regarding audio, video recordings, written observations, recordings, phone calls, written requests, or other documentation is denied. So, and that was an appropriate ruling because those are typically things that are not discoverable. There was also a motion to quash the subpoena ducis tecum. Ducis tecum is one of those Latin terms we still use as lawyers, and it just means with records. And so usually what they say is, if you produce the records to us, you don't have to come to court. So we'll excuse you from actually appearing in court if you get me the records ahead of time, because what they really want is the records. So the motion to quash the subpoena ducis tecum directed at CVS headquarters is denied. So what they said was the judge granted the motion to quash the subpoena having to do with Richard Allen's jail, mental health evaluations, mental health treatment, mental health records. But the judge did not quash the subpoena to get all of the recordings, written observations, call logs, all those things from the jail, because those things are fair game. And the judge did not quash the subpoena for his CVS employer records. The employment records. The defense motion to reconsider and request for due process hearing ordered set for June 15th at 10 a.m. The hearing currently set on defendant's request for bail is ordered converted to a hearing on defendant's motion to suppress. Okay. So a motion to suppress is a motion asking the court to keep out evidence against the defendant. So there is a motion to suppress. Now, we don't know what that's about, thanks to the gag order, but we do know that a motion to suppress is a motion to a pretrial motion to keep out specific evidence or the fruits of that evidence, as we say. So what that means is, let's say, for example, there is a computer and that computer is improperly seized. The warrant for the computer is defective, or police didn't have a warrant, or there's something like that going on. And so the judge says the computer has to stay out. That also means that anything that was turned up as a result of the computer, let's say that in the computer is an email address, and when they track that email address back, they discover that that's the email address of this person's drug dealer, and they find on the computer. A better example is they find on the computer sale records for drugs, and they find this huge distribution system going up the chain, and now they discover all of the people above this guy, dealers and manufacturers and all that, and it's a big deal. Well, if they can't use anything out of the computer, they can't use that as the basis to go out and investigate other things. So we don't know the subject of this motion to suppress. We don't know the basis or what information they're trying to suppress. But there is a motion to suppress, and that's always an interesting argument. So that will be coming up. It says the defense motion to reconsider and request for due process hearing was ordered to be set for June 15th. And then it says the hearing currently set on the defendant's request for bail, and let me see if I have that in my notes, is, I think it was also on June 15th, is going to be changed to this motion to suppress. So that'll be interesting to watch and see what happens. We do not know at this point whether any of that is going to be released and available to the public. So there is no trial date yet for Richard Allen. And the other piece of information that is kind of interesting is there was a young man whose name he's in his 30s, I think. His name is Keegan Klein. And he has been connected to this case sort of tangentially. And here's how. He was catfishing. He has been accused of illegally having inappropriate images of children, and many counts of that. And he was catfishing young girls by using a male model kind of a guy, a photograph and persona, and he was catfishing young girls. He had contact with one of the two murdered girls through this catfishing scheme. Now, there is no evidence that Keegan Klein and Richard Allen knew one another. And Keegan Kline was recently on a podcast called The Murder Sheet. He was interviewed by the moderators on that podcast and denied knowing Richard Allen. He did say that he wanted to send the podcast people a letter after he was sentenced because he did have opinions and things that he wanted to say about the Delphi murders. Keegan Kline also recently asked to, he had entered a plea and was set to be sentenced, and he's recently asked to withdraw his plea. He claims, and his lawyer has filed to withdraw. He claims that this is because his public defender was deficient in not letting him know what was going on in his case. He didn't get all of his discovery, so he didn't have an opportunity to understand the evidence against him. And he claims that his attorney did not communicate settlement offers to him appropriately. Both of those things are malpractice if they're true. So he's asking to withdraw his plea and to get a new lawyer. So we'll see what happens with that. The next one up is Murdoch. Didn't you think you were done with Murdoch? Oh, Lord, just when you think it's safe to go back in the water, he's at it again. So the one thing that has happened is that he is trying, back prior to his murder trial, he signed what's called a confession of judgment in favor of the Satterfield family. So after all the evidence came out of all the money that he'd stolen, both from his firm and from his clients, he signed a confession of judgment for $4.3 million, saying that he had stolen that money and that he was giving them a judgment for it. So he admitted to the theft. So then we go to trial. He goes through trial and admits on the stand all the money he took. So he's made all these admissions. Now his attorneys are asking to withdraw that confession of judgment, saying that he was under the influence of drugs and he was detoxing at the time that this agreement was made. It's horse hockey. If you've listened at all to what's been going on, Eric Bland, who has a great podcast called Cup of Justice, is the Satterfield lawyer. Matney and Liz Farrell, who have done the Murdoch Murder podcast, which name has just changed. I think it's called True Sunlight now, because they are really still working on trying to bring to light the corruption, especially in the South, in the judicial system. So Eric Bland talks about the fact that during the time that he was working for the Satterfields family, that confession of judgment was negotiated over a period of months, that Alec's lawyers had lots of time to look over it. They had input on the form of it. And so it clearly was not coerced, and he was not under the influence. The other thing that's happened recently, which I think his attorneys have been trying to engineer from the beginning, is that the federal government has now filed charges against Alec for all of these other financial crimes. And I don't think that's a coincidence. I think his attorneys have been trying to engineer that forever, because they want him out of state jail. They want him out of state prison and into the federal system. One, because he's probably more protected there from bad actors in jail, not quite so many people who he may have had a hand in prosecuting, or not quite so many people who know him and know of his crimes in the federal system. And by far, the federal prison is in a much better environment. We all used to call it the federal tennis camp when I was practicing, because the conditions are much better in federal prison than they are in state jail. So I think what they're looking for, and once the feds get a hold of you, they take priority. Their sentences, you have to serve their sentences first. So I really think his lawyers are trying to get him as much time in the federal tennis camp as they can before he has to go back and serve state time. That works in two ways. One, he spends less of his life in state prison and gives it time to sort of fade into the background, because right now the case is fresh. It's fresh in everyone's mind. But let's remember that prison population turns over, and that 5 or 10 years from now, people aren't going to feel the same about Alec Murdaugh that they do now. So I think this is a concerted effort by Frank and by Jim and Dick to get him out of state prison and into the state system. Now, I do want to point out, because we all saw during the Murdaugh trial, we saw Tony Satterfield, and we all fell in love with him. So what I want to point out is that when Eric Bland began pursuing getting the money back that Alec had stolen, he went to all of the bad actors. He went to Murdaugh's, at that time, firm, PMPED. It is now it's named for one of the partners, the Parker Law Group. So when he went to them and said, you should have supervised Alec, you should have caught him thieving on all of this millions that he stole, and you are responsible and you have to make good on it. And the firm did. He also went to the banks and said, you had a responsibility to make sure that this Forge account wasn't fake, and you didn't, and so you're partially responsible. So the Satterfield boys, they're adult men, but everybody calls them the Satterfield boys. The Satterfield sons have recovered actually more than the original recovery, more than the $4.3 million. That does not take Alec Murdaugh off the hook. He stole the money, and he needs to he needs to make that right. But the recovery, when Alec put the claim in, he put the claim in against his umbrella policy, which was with Nautilus Insurance, and Nautilus Insurance paid that money out to Alec, thinking that it was going to the benefit of the Satterfield sons. Alec stole that money and didn't pay the Satterfield sons the money. So Nautilus's claim is not against the Satterfields, who have recovered from completely different entities for their misconduct. Nautilus's claim is against Alec Murdaugh. So a lot of people were worried that the insurance company was going to be able to come back and recapture that money from the Satterfield sons. The source of that money was not Nautilus. The Nautilus money Alec spent. So it's up to Alec to figure out how that money is going to be recouped. I think it's possible the court may say, regardless of where the source of the money, the Satterfields have been made more than whole, and may transfer that judgment from the Satterfield boys to Nautilus Insurance, which is actually where it ought to be. So I think Nautilus is suing Alec, trying to get money back. And Alec does have money because there is a family trust now that came from his father, Rudolph. He has a share in this family trust. But remember, trusts can't be invaded. The principal can't be invaded. There are what are called spendthrift provisions that keep people from spending the principal of a trust. So he can't get into that trust. He can only get what the payout is from the trust. But all of the money that everything he owns is still in the hands of the receiver, who's been deciding who gets what. Now, Dick and Jim got $600,000 out of Alec's retirement for his court case. That, of course, got eaten up when you're paying $20,000 a week to rent an entire resort so that you can be there and do trial preparation. You blast through that money pretty quickly. So that money is gone, and they then asked the court to authorize another $120,000 to come out of Alec's money for Alec's appeal. And the court said, don't think so. So I don't know where Dick and Jim are going to get the next $600,000, but it isn't going to be on the backs of the people Alec stole money from. So that is the Murdaugh case. And I suspect that Alec is going to plead guilty to all the federal charges, and he's going to ask for as much federal time as they can give him, because then he's going to be in the comfy federal tennis camp and not in state prison. So we have a couple more cases I want to talk about. I want to talk about Dylan Rounds, and I also want to talk about Petito and Laundrie. So Dylan Rounds, young 19-year-old guy whose dream had always been to do dry farming in Utah. So today, actually, I believe it was today. It might have been yesterday. It was Memorial Day weekend. It's been 1 year since Dylan disappeared, and since his family called police saying we haven't heard from him and we're worried. Dylan was living on 600 acres of dry farm. The closest community was like 2 hours away, and it was a small little town of 35 people. And Dylan's body has not been found, but officials are certain that he is deceased. So the family is still searching every weekend and scouring the area looking for Dylan's remains, and they're absolutely not satisfied, will not be satisfied until they can bring Dylan home. However, there was a man squatting on Dylan's property. His name is James Brenner. He was not a great guy, had a lengthy criminal history, including violent crimes. And he was charged. This is another bit of technology. I mean, another way that technology is really beginning to solve a lot of crimes. So the most interesting thing that happened was they started looking for Dylan's phone, and they were able to find a signal from Dylan's phone and discovered it was in a pond. And believe it or not, even though it had been submerged, they were able to find it. And when they downloaded his phone, they discovered a video of James Brenner. It was a weird, probably accidentally filmed, sort of like Alec Murdaugh not knowing that Paul was making a video in the background as he was yelling at Bubba. The video was made, and it was James Brenner wearing a bloody shirt and cleaning a gun. And when the search was done of Brenner's home, they recovered the shirt, they recovered and discovered that Dylan's bloody boots, as well as Dylan's blood, was all over this guy's trailer. So they are convinced that Dylan is deceased. We don't know anything more about whether or not Brenner has disclosed anything about the murder, anything about how it happened. We don't know anything about that, and Dylan's family is still searching for his remains. They understand and believe that he's deceased and was murdered by James Brenner. But they are looking for him. And finally, let's talk about Petito and Laundrie. As you recall, Gabby Petito was murdered. Brian Laundrie left her body in Wyoming and took her camper van and drove back across the country and went home to his parents in Florida. After a few weeks of the Petitos begging for Brian to tell them where Gabby was, Gabby's body was discovered in Wyoming, and Brian disappeared into the Florida swamp. A few weeks later, Brian's body was found, and he had taken his own life. There was a confession letter of sorts in a journal that he had written, and later they found a letter, and on the outside of the letter was written by Brian Laundrie's mother, and it said, the outside of it said, "Burn after reading." Now, the Petito family has claimed that this was a letter that, and the Petito family knew of the existence of the letter and demanded it in discovery, and the Laundrie family did not want to produce it. So there was a hearing last week, and during that hearing, the judge ordered them to turn the letter over. So they turned the letter over, and of course, the Petitos released it, and it hit the internet. You can find it out there. So Mrs. Laundrie's position is this: you can believe it or you don't have to believe it. I have a real problem with the Laundries. It was wrong of them to withhold any information. It was wrong of them to protect their son, Brian. It was wrong of them on so many levels, because the Petito family's lawyer claims that as early as August 28th, the Laundries knew that Gabby was dead, and that they didn't tell the Petitos. And that is the subject of the current lawsuit, because you can't prosecute someone who's dead. So Brian Laundrie's dead, Gabby's dead. There's no criminal charges going on, but the Petitos have sued the Laundries for intentional infliction of emotional distress. That's a civil case. It's a tort. And so in the civil case, they're looking for civil damages because they think that the Laundries purposefully and intentionally caused them that agony of not knowing where their daughter was when they knew. So that hasn't come up hasn't come to trial yet, the issue of whether or not that constitutes intentional infliction of emotional distress. The judge did uphold it and say that there was enough evidence for it to go to trial. Similar to a probable cause hearing, there was a summary judgment hearing in the civil case. So, but Brian Laundrie's mother's position is that she wrote this letter months before, that it was a takeoff on a book, which if you Google it or you put it in on Amazon, there is a book called Burn After Writing. And it's kind of a guided self-help book where it asks you questions and you write about the answers. And it is intended to be sort of a mechanism for self-evaluation and self-examination. And so she had given him a copy of this book for him to work on. and it is called Burn After Writing. The idea being that this is your journal. It's only between you and the book, and that afterwards, if you've gotten something out of it, fine, burn it. There certainly is a more sinister interpretation to be made if the letter actually was written after Gabby was already dead. Now, she also makes references to some other personal comments that she makes to him. One of them is, if you need to bury a body, I'll bring the shovel. And I mean, it's probably, we see that meme. We see this meme on Facebook all the time. We're such good friends. If you need to bury a body, I'll bring the shovel. Those sort of things are out there, and people pass them around all the time. She claims that the things that were said in the letter are being taken out of context, that they were inside jokes between her and her son. I'm not defending anybody. You can make up your own mind what you think about it. The letter is undated, and there is absolutely no evidence when the letter was written or when it was received. If you think about the fact that it was recovered, I think, out of his car, he didn't burn it after reading. So, it sounds to me like, at least that goes toward the idea that maybe this was a joke between them. I don't know. There is absolutely no doubt that the Petitos suffered horribly while they were waiting to find out the fate of their daughter. And there's absolutely no doubt that she died at the hands of the Laundrie's son. But Gabby and Brian were both adults. And unless there is a way to prove that the Laundries were complicit in covering up Gabby's death and Brian's involvement in it, then I think they're kind of stuck. I don't know what the court is going to do with the damages claim. That's going to be something that the judge is just going to have to hear the facts and decide. The other interesting piece is that the Petitos filed an amended petition and added in the Laundrie's New York lawyer. And they added the lawyer in because he made a public statement about the case. And his public statement was, "We hope that the search is successful and that Ms. Petito is reunited with her family." Now, the Petitos say that the Laundrie lawyer already knew that Gabby was dead, and that what contributed to their damages, their emotional distress. I think that one's a reach, and I think the judge is going to dismiss the lawyer out of the suit. I don't think it's going to be, I don't think that one's one that's going to stand up. So I have been through all of these, and it's time for questions. And I'm sure you have a gazillion questions because we've talked about a gazillion cases, or at least 1, 2, 3, 4, 5, 6, 7, 8. So we'll take some questions. I might be ending a little early. I might be running out of voice, so stick with me here, and we'll try and get through as many of your questions as possible. Thank you. Tonight we have 652 folks in chat tonight. Thank you for joining us. And we'll move on to questions. Hey, Trisha the Trucker, be sure and tell us where you are. We always like to know where you are. And why wasn't Lori's financial crime, why weren't her financial crimes federally charged? Well, this is again, I think this is a belt and suspenders situation. Just as we had the Idaho charges go first, and then we had the the Arizona charges come behind, we may still see federal charges. But as long as the federal government is satisfied that she has been brought to justice and that restitution is being sought, although they're never going to get any money out of her, then I think the federal government probably is satisfied and won't file those charges. Oftentimes, if we see state crimes and federal crimes, we don't see it elevated to the federal government unless there are no state charges, or unless there's a bigger penalty that can be got out of the federal charges. So in Murdoch's case, we're seeing federal charges that are coming out of money laundering and those sorts of charges that are more serious than the state charges. So usually the feds are going to defer to the state and let the state handle it. And then if for some reason the state can't handle it, or the feds can come up with more serious charges, they usually leave it to the state. So I hope that's clear. Be sure and tell us where you are, Tricia. Hi, Jan. Question. I'm convinced that Bad Lori really didn't believe what Chad was putting down. She lied to cover up everything. My opinion? I have said from the beginning that I think Lori's a true believer. Now, I think she lied to cover up everything. There's no question of it. She lied from the beginning to cover her tracks. I do not believe that she was incompetent to the point where she didn't know what she was doing at the time the murders were committed. So remember, there were two different questions. It was never discussed whether Lori was competent at the time the crimes were committed. Her competency to aid and assist her lawyer and to stand trial was the only issue why her trial was stayed. So I do honestly believe that Lori believes that she is God's chosen, that she is a goddess, that Chad is a prophet, and that she is stuck in that mindset. But I also believe that she lied to cover everything up. She lied to cover her tracks because she knew that what she was doing was wrong. So that's a good question. And I think, it's strictly a matter of opinion. If you talk to 5 people, they're all going to have different opinions about it. I am not utterly convinced that Chad believes now what he did then, but I am convinced that Lori still believes it. This is the very reason why she was not willing to let her attorney throw Chad under the bus, throw Alec under the bus, because she still believes it. Hi, Janet. Question. In my opinion, Roberta so wrote that letter after he came home without Gabby, or on his solo trip home in August. If it was August, would that make Roberta an accessory before the fact? Well, I'm not sure it would make her an accessory before the fact. I think that their behavior after Brian came back is more telling than what might have happened before he got there. I think that that their actions in sheltering him, covering it up, harboring him, keeping the media away, keeping law enforcement away, keeping the Petitos away, I think those are more telling than this letter, frankly. I think the letter is kind of, if I were the lawyer, I would think this letter would be kind of unreliable evidence, frankly, because it's not dated. We don't know. There seems to be at least a plausible explanation that could raise reasonable doubt if it were a criminal case. If we were prosecuting Roberta Laundrie, I would think that would be weak evidence. There's much stronger evidence that they were complicit in after the fact in helping him cover it up. So, but good question. I love the fact that y'all have become such educated consumers when it comes to our show that you ask me these nuanced questions. You're not asking me the straightforward, easy questions. You're really digging in because you've learned a lot, and I'm glad about that. I'm excited because that was a lot of the reason I wanted to continue. I wanted to do this channel. So, thank you so much for your donation. I just saw that donation. It wasn't even a question, just a little super chat. I want to remind everybody that all your super chats go directly to our moderator. Right now, we just have one, Michelle. And believe me, it makes all the world a difference to her. Hi, Sarah. I hope Oregon is treating you well. I hope the weather's improving there. The weather's been beautiful here in Idaho, finally. I'm not good at overcast, cloudy days. I have a little of that seasonal stuff. So, Sarah, why plead guilty when he's guilty? Why plead not guilty when he's guilty as sin? Most of which we know about. Even if in his wildest dreams were found not guilty, he's got life in prison ×2, right? At Michelle Evening. I'm not sure which he we're talking about because we've talked about several cases, but I'm assuming that you're talking about. I'm not quite sure who you're talking about. If you're talking about Kohberger, it's way early in this case to. Oh, Alec. Oh, I gotcha. Okay, now that makes sense. The reason why is because if he pleads guilty to all of those federal charges, he has to serve his federal sentence first. Once the feds get a hold of you, their sentence always takes priority, regardless of whatever else is hanging over your head. So if he pleads guilty to those federal crimes, then he serves the federal time in a federal prison in the federal tennis camp. Much nicer facilities than state prison. Plus, let's just say he pleads guilty to those federal crimes and he gets 10 years in federal prison. Well, that's 10 years that he didn't have to serve in state prison. And there's a lot of prison turnover, population turnover in prison. So it's 10 years for people to sort of, their memories to fade about what he did and for him to be less likely to be dangerous in general population or be in danger in general population. So the two reasons are gives time for things to calm down and people to sort of lose track of what his crimes are in state prison. And it also gives him as much time as he possibly can do in federal prison. Because, yeah, he has 2 life sentences and he's going to serve his life in prison. We know that. So his lawyers are just trying to get as much of that in federal prison as they can. So if they can plead him out to umpteen federal crimes and let the feds stack those crimes up, so he's got 30 years in federal prison, that's 30 years he's not in state prison, and he's at the federal tennis camp. So that's the reason why. Thanks, Sarah. Trisha the trucker, I'm driving into Kansas City tonight. Excited I get to sleep in my own bed in the middle of the week. Way to go, Trisha. We hope that you have a great middle of the week and safe travels. Intervisions. Is Lori's case be appealed to the Court of Appeals or the Supreme Court? What are the chances the court, whichever, will approve the petition? Good questions. So had Lori's case continued to be a death penalty case and she would have been entitled to have her appeal go directly to the highest court, to the Supreme Court. Because death penalty was off the table, her appeal will have to go to the Court of Appeals. Now, the Court of Appeals has to hear all the cases that come to them. They don't have the ability to say, we're not going to hear this. The Supreme Court, on the other hand, can say, we're going to uphold the appeals court, and they can do what's called affirmed without opinion. We called it AWOPT. And what that means is that the Supreme Court could say, if Lori's case goes to the appeals court cannot refuse to hear it. They have to hear it. If they uphold her conviction and she then appeals to the Supreme Court can say, we're going to uphold the decision of the appeals court. So it does not go directly to the Supreme Court because it wasn't a death penalty case. Great questions. Very nuanced, folks. These are not easy questions. Hey, Tammy Williams. Good, Lori. Are you going to try to interview Bad Lori for your book? I absolutely am. There's nothing that can move forward until she's sentenced. And her attorneys may recommend that she not give any interviews until her appeals are all exhausted. And that could be years. But I'm absolutely going to try because I have questions. I mean, we all have questions, but I have questions. And I think that it is fair, and y'all know I like fair. I think it's fair to at least offer her the opportunity to tell her side of the story. Is that going to change anyone's opinion about what happened or what she did? Probably not. But I do feel like the legal system meant that she made some tactical decisions not to testify, not to present her case, not to say what happened. And that has been going on all the way along. But what haunts me are the phone calls that she had with Colby and with Summer saying, you don't understand. You don't know, you don't understand. Because we all really want at the heart to understand. Now, it doesn't make what she participated in any less heinous, and it doesn't make her any less guilty. But if our goal is to understand so that we can protect kids from this happening again, if our goal is to understand so that our better angels can prevail, then we need to hear her. Just the same way we needed to hear Ted Bundy, and we needed to hear Israel Keys, and we need to understand so that we can do this better. And so I want to offer her the opportunity to help us understand. Now, I don't think that changes in any way her culpability, and it sure doesn't change in any way people's opinions about what happened, and it's not going to change the verdict. But maybe it helps us be better people by trying to understand. So yeah, I'm going to ask. I'm not holding out huge hope, but we'll see. I certainly don't think that she will do anything until after sentencing. That would be the wisest course. But I hope at some point she'll talk to somebody about it. And why not me? So, Sarah, do you think she'll ever really be honest with anyone? She loves her games. Oh, I agree. I don't think she'll ever be 100% honest with anyone. I think it's interesting. Anne Rule, who was, the godmother of true crime, if you will. she said that about all of the people that she interviewed. She interviewed Diane Downs, and she said of her, she will always try and manipulate people's opinion about her because that's who she is. And she will always try and put herself in the best light. I don't know whether Lori would ever be honest with anyone. And believe me, people who can participate in the mental gymnastics that it takes in order to commit the crimes that she committed are perfectly capable of trying to manipulate anybody they talk to, including her lawyers, including people who interview her. But I spent 27 years talking to people who committed crimes and who spent a lot of time trying to manipulate their lawyers. So I've done that dance a time or two, and I feel like I have experience at it. Now, am I the best person in the world, and do I catch every time somebody's trying to play me? Nope. But I've had a bit of experience at it. So I'm hoping that somebody with that kind of experience will get the opportunity to talk to her. Any chance of Melanice being indicted now? I have said, thanks Maxine for the question. I have said from the get-go that I think it's about 50-50 at this point. And I don't think we are going to know anything more about what's going on in Arizona until Lori's sentenced. I could be wrong. They could be dropping charges left and right. They have already said they intend to extradite her back to Arizona to answer for the murder of Charles and the attempted murder of Brandon. And so we'll see what happens. I think it's very possible. I think Melanice, that is Melanie Boudreau Pulowski, Brandon Boudreau's wife, ex-wife. I think that she was one of the only people who knew where Brandon was living. He had given her the address because he was ordered by the court to do it. She was the only person who was in touch with Alex. We know Alex Googled Brandon's address and directions to that address from Rexburg. So I mean, I think it's very possible that she will be indicted as a co-conspirator. But I think we're going to have to wait to see that what happens. I really think Arizona was waiting to see how cooperative she was going to be with Idaho. And we all know now that she wasn't cooperative with Idaho, that she didn't follow the directions of the court, that she listened to Brandon's testimony, that she read news coverage, and that she, as a result, the prosecution decided not to call her as a witness, which I think was a smart call on their part. They had enough on their plate. They didn't need to fight that battle. They could get anything they needed in through Ian, and the court let him testify. So I think it was smart on their part to just not fight that battle at that point. So we'll see whether she gets indicted or not. Christy Rogers, you keep saying Alex would be in federal camp, but those are for nonviolent criminals. Wouldn't his state murder convictions make sure he lands in a federal max prison? That is really going to be up to the Federal Bureau of Prisons. They will do an assessment and they will decide. I don't see him being in a supermax prison, but it probably will be in a medium to high security prison. He'll be in a prison where violent offenders are, but still federal prison is the environment is much better than state prison, even in the max security prisons. So I don't think he'll go to a supermax. I don't think his crimes rise to that level. I do think he'll be in a max security situation because of the murder convictions, but I still think he will be immensely more comfortable in federal prison than he would be in state. Good question, though. Did Lori Vallow file joint tax returns the year Charles died? Wouldn't you love to see the IRS go after her? Well, that's a good question. We know that she called her accountant and asked for copies of her tax returns. And I'm not a tax expert. My understanding is it depends upon when the death occurred. If it occurred in the second half of the year, she would have been entitled to file joint tax returns for that year. If they were married more than a year, more than half the year, more than half the year. So Charles' death happened a few days into the second half of the year. So she may very well have been able to file those joint returns for the year he died. So we'll see. She has got an awful lot on her plate. She is never getting out of jail. So, and I'm much more concerned about making sure that she is held fully accountable. I know there were some people who said, why in the world is Arizona going after her after she's going to have 2 life sentences? And the bottom line is because Charles deserves justice too. So I'm thrilled. Maxine, thank you for your sweet comment. I love answering questions. I'm thoroughly enjoying the process of writing the book. Just found out CrimeCon in 2024 is going to be the end of May, 1st of June. We still don't know where. They don't tell you where until this year's CrimeCon. So we don't know where, probably on the West Coast somewhere. And I am hoping that we're going to launch the book, the pre-sales for the book at 2024 CrimeCon. My publisher tells me that if I stay on schedule, we're hoping to have the book out in September for a book release, but we'll be doing pre-sales. I hope that'll be our big launch at CrimeCon. So thank you, Lori, for answering my question. I agree. Even a higher security federal prison is going to be much nicer than state because they have much better funding and facilities. And that's just the truth. Yeah. And they tend to have not only, they just have more comfortable facilities. And they also have a different system by which inmates can earn privileges and creature comforts. So yeah, just things like they got a better selection in their canteen, better stuff. In state prison, if you need a new pair of tennis shoes, they are Chinese knockoff tennis shoes. They are not going to be Nikes. But if you go to federal tennis camp, it's possible you could get a much better quality of stuff in your canteen and have just creature comforts. There's just more access to them. Oh, thanks, Michelle. Thanks for all of you who buy me a coffee every now and then. I appreciate it. We know I love my coffee. And I couldn't have gotten through Lori Vallow's trial without it. And now I won't get through writing this book without it. Hey, Squeaky Wheel. Question, could Idaho and Arizona make a sweetheart deal with Chad where he'd admit to his part, who killed who, and when, explain the ambush on Charles and Brandon, and tell how Alex died? Similar to BTK. Okay. I think it's possible. I think if I were his lawyer, I'd be trying to put something together like that. But let's remember, Chad wasn't charged in Arizona. And the prosecution in Arizona said they didn't feel that they had sufficient evidence to link Chad to the conspiracy to kill Charles. So he wasn't, he was, it's hard to make a deal with Arizona if you don't have pending charges, because that's what you hold over people's heads to get them to make a deal. So I'm not so sure that could happen because there's no pending charges there. Good question, though. And I will tell you that early on, when we hadn't seen the Arizona charges yet, I really felt that at some point Arizona and Idaho were going to work together to put the pressure on them both. Um, it appears that some of that happened, but probably not as much as we would have expected. Mostly because Chad wasn't charged in Charles's murder, and we haven't seen any charges having to do with Chad and the conspiracy with Brandon either. It could be coming, and we don't know it yet. Didn't Pryor say Chad had details about Alex's death, implying he knew what really happened? I don't remember that. I don't recall that right offhand. Um, I have my own opinion about Alex. I think he was very gullible, and I think they convinced him that it was his time. And I think it's possible that he took his own life. But I do not recall Chad or Pryor saying that Chad had details about Alex's death. That doesn't mean it didn't happen. I mean, this case has an awful lot of moving parts, and sometimes things fall through the cracks. So, um, if anybody else knows about the source of that, let us know. Linda Stewart. Will Lori get mental health counseling when she gets to prison to deal with what she's done, or will she just vegetate? Mental health counseling is available in prison. It varies from the kind of programs that are available, vary from state to state. There's usually group treatment kind of groups, and they tend to focus more on drug and alcohol treatment, but there is mental health treatment available. Inmates have a choice as to whether they take advantage of those things as well. So for her, it will be her choice. If she decides that she does not want to avail herself of that, she can't be forced to do that. She will still be offered her psychotropic medication while she's in jail. And if she has a meltdown in jail, in prison, they can forcibly medicate her. And no, they don't have to let her leave prison to go to the mental hospital. They will treat her in prison, and they will forcibly medicate her if necessary. Flashback. What do you think of Gigi writing a Vallow book? I just heard that. I think it's a big field. She did a lot of research as she was putting together that deep dive series, and I love Gigi. I wish her well. I think it's a big field. I have told you all that I have read and enjoyed immensely Leah Sotilli's book, which is called When the Moon Turns to Blood. She took a very different approach to the story than I will, and than I am. Her approach to the story, the entry point for her was political and religious fundamentalism, and how that played into some of the choices that may have happened. So her book was not only about the Vallow case, but about a lot of other cases that involve political and religious fundamentalism, like the Bundys and the John Birch Society. She goes into the deep history in having to do with fundamentalism. And so I think that it's a wide field, and I'm excited for her. So, I I didn't start out writing a book about the Vallow case thinking that mine was going to be the only one. I hope that it's going to be a good book and people are going to enjoy reading it, and that they'll get important insight into the case that way. And we'll see how it goes. But I'm happy for Gigi. Christy, it may have been that Pryor implied Chad had details about Charles' death. It was either Charles or Alex. He mentioned it when he was arguing to sever the trials. Ah, okay. Um, well, I think there was an argument to be made at trial that that there could be information um, about one or the other of the co-defendants that would justify the trial being severed, and that was the um, evenings moving on, and I'm getting a little tired, so my brain is not popping up as quickly. But that was the argument was that if one of them had made a confession, that it could implicate the other one. So I don't recall a specific instance of him saying, intimating that they had information, but it may have been used as a hypothetical, like what if, and hypotheticals can also be used to sort of transmit hints that you might know more. But I think at the time it was just being offered as a what would happen if one had information and was willing to um, make that information available. So that's always the question when you're severing cases. I don't remember specifically there being a suggestion that he knew more about Charles's death or about Alex's, though. Zelke? I'm having trouble focusing on my screen tonight. We've got the white on green letters, and I'm having a little trouble with it. But question: with them not having enough to link Chad to the Arizona crimes for charges, can the Arizona stuff come in at Chad's trials? Could Chad use that to suggest it was all Lori and Alex? Well, he could, but I think that it's going to be a little bit different for Chad than for Lori in terms of what comes in. I think first of all, I think Pryor's going to fight harder to keep some of that stuff out, but I think it will come in to show a pattern or plan, and there doesn't have to be a conviction or even a charge in order to be able to bring that in and say, this shows the planning and the pattern. So I think some of it will come in, maybe not as much as came into Lori's trial. I actually have said I was a little surprised that the court let them go that deeply into Charles's case, that deep into the detail. I mean, really, the only thing they weren't allowed to say was that Lori had been charged with his murder. That would have been too far. So Debbie Biggs, question: will your book be in audio form also? My publisher, part of my publishing contract is that they also have the rights to an audio book. I'm assuming that they will make an audio book. I have talked to authors who have voiced their own books, and for the most part, they say, don't. If you're not a professional, don't. So some people have asked, will you do your own audiobook? And I've said, probably not. But I'm assuming it will be available in audio form at some point. And I love audiobooks, frankly. When I am doing, I know I showed this last time, for those of you who weren't around, when I'm doing this kind of research, I want paper that I can make notes on, and I can highlight, and I can stick tabs and all that. But if I'm listening to a book for enjoyment, I enjoy books, audio books. Then I can, do the dishes or quilt or take a walk or, while I'm reading as well. So I'm big on multitasking books. So I'm drinking my orange juice tonight, guys. I'm yes, Michelle, bless her little pea picking heart, um, fell and bumped her head earlier in the day and had to go get a CAT scan and has a little bit of a concussion. So she says she needs to ice her brain. So I think now would be a great time for us to wrap up for the evening and call it a night. I'm gonna go drink orange juice and maybe take a COVID test. And Michelle is going to go ice her brain. Michelle's got some family in from out of town, so she'll have a few more minutes with them as well. So let's wrap up. I just want to say thanks to everybody joining us tonight. We had over 600 in the chat. If you have not subscribed, please do, because you'll get notices when we go live for little surprise lives when stuff happens, and it will continue to happen. And be sure and hit the notifications as well. Hit the thumbs up button on your way out, please. It really does help us with the algorithm. I want to thank all of you that were so patient. Well, a couple of weeks ago when my daughter was getting married, thank you for all your sweet wishes and all your lovely comments on the pictures. And I want to say good night. Have a great week. And we will see you next week on True Crime Wednesday. Join us then.